Good evening, ladies and gentlemen. I, Shubhra Khanna, LLM student of the Indian Law Institute, New Delhi, and a proud ex-student of Universal Institute of Legal Studies, welcome you all on the occasion of Dr. L.M. Singhvi Memorial Lecture to be delivered by eminent jurist Professor Upendra Baxi shortly. On the dais, we have with us Professor Upendra Baxi, Honorable Justice A.K. Sikri, Mr. Salman Khurshid, Dr. Abhishek Manu Singhvi, Dr. Manish Arora, and Dr. Lokendra Malik. Professor Baxi will deliver the Dr. L.M. Singhvi Memorial Lecture on Demosprudence V Jurisprudence, the changing character of judicial review in India. Honorable Mr. Justice A.K. Sikri, Judge Supreme Court of India, will preside over the function. Shri Salman Khurshid is gracing today's function as the guest of honor. Dr. Abhishek Manu Singhvi is also gracing the function as the guest of honor, a worthy son of a worthy father. Dr. Manish Arora is the director of Universal Institute of Legal Studies, New Delhi. He is also an advocate of the Supreme Court of India. Dr. Lokendra Malik is practicing in the Supreme Court of India as an advocate.
Good evening, everybody, ladies and gentlemen. I welcome you all to this gathering. In fact, we are here today for a lecture in the memory of a great jurist, parliamentarian, and an intellectual par excellence, Dr. L.M. Singhvi. On behalf of Universal Institute of Legal Studies, which is an educational wing of the Universal Group, which is in the service of the legal profession since more than 60 years now, and on behalf of the organizing chair, Mr. Lokendra Malik, I welcome you all to this memorable event. Dr. L.M. Singhvi, that is Dr. Lakshmi Mal Singhvi, was an eminent jurist, a leading constitutional expert, an expert in public and private international law, a distinguished parliamentarian, a high respected intellectual, a prominent exponent of human rights, a doyen of Indian bar, a citizen statesman, an author, a poet, publicist, linguist, and a literature. Dr. Singhvi was elected to the Indian Parliament way back in 1962 to 67 as an independent member from Jodhpur parliamentary constituency. Dr. Singhvi was elected as president of the Supreme Court Bar Association on more occasions than any other leader of the bar except the late Shri M.C. Sitalwat. It was Dr. Singhvi who conceived the Law Day, which Supreme Court Bar Association has been religiously following and celebrating every year on November 26th.
We have two outstanding people in our midst today. Both the president for the evening, Justice Sikri, who is, I think, one of the more sought-after persons on the lecture circuit, particularly amongst lawyers across the globe, and, of course, Professor Upendra Baxi, for whom I can only say my greatest regret is that I never was your student, at least in not in a formal sense. But I have a little memory that you might not have kept intact. I was at Oxford, and I heard a lot about you, and I wrote to you saying I wanted to come and work under you. And you sent me back a letter, and I didn't understand, because in Oxford everyone was addressed as dear Mr. So-and-so and dear Mr. So-and-so, and you wrote to me as dear friend, and I thought, my God, what a wonderful thing it must be to work in Delhi University under Professor Upendra Baxi, because I'm already his friend. And if I go and work in Delhi University, how wonderful it would be. Unfortunately, you had some technical problems. The technical problem was that I didn't have then a PhD, and you told me to get myself a PhD, which I'm still trying to get. And for that reason, I couldn't join you on your faculty. But I know that people who have been through that faculty and have had the privilege to work with you over the years, and that's not just people in India, but people that I have met across the globe, in Australia, in different parts of UK, in the United States of America, that if there is a significant impression on their minds about India's academic contribution in the field of law and jurisprudence, amongst the names that shine gloriously, yours shines absolutely at the top. I think we have very good fare awaiting us, and I would then just simply say, let us all put our hands together for two very remarkable people, Justice Sikri and Professor Upendra Baxi.
This is not a story, it's true that as a very young 30-year-old Lok Sabha member, independent, who was in awe of Nehru, but who used to oppose Nehru in Parliament, he toured Scandinavia since he had done his PhD from Harvard and Cornell, and he was fascinated with the ombudsman system. And he started speaking on the ombudsman in '62 in Parliament. And in the corridor of Parliament, Jawaharlal Nehru once accosted him and said, "Young man, you are constantly using this phrase ombudsman. To which zoo does this animal belong? And you must indigenize it, because this is too foreign sounding." After which he actually coined Lokpal, as you've been told. It was, of course, a supreme irony that I was able to quote this example in a footnote in my preface as chairman of the parliamentary committee, which was tasked with the idea of creating a Lokpal. And the debates reflect in '62, this whole debate on ombudsman to Lokpal. The second was the law day, which I witnessed before I joined law, when we were traveling from the Supreme Court back home, and I happened to be with him for something, and the late Justice Surila Bhandare was either the secretary or the vice president of the Supreme Court bar. And just while going to the car, he came up with this idea that the day the Indian Constitution was completed ought to be commemorated, because 26th January, Republic Day, is a different kind of a commemoration. And he actually drafted the charter single-handedly, partly that day and partly the next, and then ceaselessly worked to make it a part of the agenda, first of the Apex Court, and then of each and every High Court.
LM argued the first case on the unconstitutionality of death penalty, and delay was one of the grounds. Bachchan Singh, I think. And I was privileged to assist him in that proceeding. I couldn't appear at that time before the Supreme Court, but I did the next best thing, namely to mislead as much as I can LM Singhvi. And he was willing to mislead. Demosprudence has come to stay. Judges are constructing and reconstructing the people of India in actual cases and controversies they take up. Justice Khanna, in fact, as far back as Indira Nehru Gandhi versus Radharan, 76, said, "Well, I didn't mean this in Keshwananda. I meant that X, or I didn't mean X, I meant Y when I said that in Keshwananda." So he invented, which would have displeased LM to no extent, he invented something not known to English jurisprudence. So a phenomenon of retroactive dissent from one's own opinion. I've never heard it, nowhere in the world this happens. Now, Khanna was not trying an SL at that time, but our justices, barring the present ones, regularly, barring those present, regularly depart from their own decisions without feeling the need to explain, because they are practicing not jurisprudence but demonstrance, without feeling the need to explain why they are short-circuiting the precedent. So socialists like Pratap Mehta and others, I don't call it an irresponsible criticism, but when they talk of judicial sovereignty or judicial overreach, they're living in the old world of jurisprudence, where judges did certain things the executive did certain things, and legislature did certain things. Now judges have emerged well and truly as co-governors of the nation. But now the judges want to make sure which plan is right for Ganges, which plan is right for inter-reverse utilization, which plan is right for black money. So they are governing the nation. And we must not forget, therefore, people like Manu Mehta or Manmohan Singh, who occasionally complain of judicial overreach. Manu Mehta's term is judicial sovereignty. They are using the old standards to judge the judges. I say judging the judges is a very complex business. And LM knew that. It's a risky business, of course, but it's also a complex business and contradictory affair. And judges today practice demosprudence. But I must now end by saying two things. Is what I'm saying true? Wholly true, or partly true, that judges are embracing demosprudence? I do not know the answer because just begun the work on it. So in one judgment we are asked to go to the parliament. In another judgment, the parliament enacted law is itself overruled by their lordships. So demosprudence, yes. But sometimes one should ask, what are the costs? Who bears the costs of demosprudence? The people of India, the minorities of India. Is that all right? Well, some of you might say it's all right, and I end here. Some of you might say it's all right for a while, but not for a long time. Some of you might want to say it is all right 80%, but not for 20%. I think socially responsible criticism of justices must reject these answers. It should establish a theory of judicial demosprudence, first of all, what it looks like, and then critique it on its own terms. There are three jobs involved. Socially responsible criticism, to conclude, means to analyze the judges' judgments on their own terms. Two, to faithfully report what the judges mean what they say. Do not look at what the judges say, but look at what they do with what they say. And the third step is what you want to say about this demosprudence of the court. I think the work has just begun. Demosprudence is a difficult concept. Some might say better concept than jurisprudence, because it is more inclusive of people than jurisprudence could ever be.
Let me confess at the outset that when Dr. Lokendra Malik came to me and said about this Dr. L.M. Singhvi Memorial Lecture to be delivered by Professor Baxi, and he wanted me to preside, it was not an easy decision. Primarily because of the reason that I knew when Professor Baxi speaks what would be spoken about us as Supreme Court of India. And I should be there to receive all that onslaught. Notwithstanding this, I agreed to be here today willingly and happily, let me tell you, and for two reasons. One reason, or the first reason, was again Dr. Baxi himself, because it is always a treat to hear Dr. Baxi. I remember those days when in those extra classes, if the seats are there for 50 or 60 students, there would be 200 students attending those classes. And I wanted to listen to him as a student again. And second reason, of course, was Dr. L.M. Singhvi. I was a new lawyer and would engage him as my senior in many cases. And I still remember the warmth in his hospitality, which would come in the form of delicious sweets from Rajasthan in every conference which we used to have with him. As far as the lecture of Professor Baxi on Demosprudence versus Jurisprudence goes, this itself was a kind of jurisprudence, if I would say, which he has very succinctly demonstrated. Maybe, as he has himself pointed out, that this idea of demosprudence he has taken from Professor Lenny Gunier, who spoke about it in the context of American law a few years ago, but has totally translated it into the demosprudence which Indian Supreme Court is professing today. Professor Baxi has said and has given some of the instances where Supreme Court may have, in the opinion of some jurists, if there are any, or thinkers, overstepped and violated the principles of separation of powers. Even in such cases also you will find opinions are on either side. There would be many who would like Supreme Court and High Courts, that is all constitutional courts, to do that. Of course, debate would still remain whether it is necessary at all for the court to be catalyst and doing this job which is meant for, or what is the arena earmarked for legisprudence, as Professor Baxi stated. Former Chief Justice of Israel has provided a very beautiful answer in his book titled The Judge in a Democracy. He rejects the contention that judge merely states the law and does not create it on the hypothesis that the law keeps on changing over a period of time, which is primarily due to the interpretation of a legal text and that involves creation. And on that basis, he concludes that the judge creates law. Justice Barak thereafter explains the role of a good judge. He says, yes, it is the role of judge to decide a case which comes before him. That is the role of every judge. But what is the role of a good judge? How a judge becomes, within inverted comma, he says, good judge. Role of a good judge in this creative process is to establish a judicial policy with formulation of a systematic and principled approach to exercise his or her discretion. I entirely, agree and say that yes, when it comes to judging the Constitutional Court in India, and there Professor Baxi would immediately reply, okay, even if you have this standard, where is the particular or definite judicial policy which Indian Supreme Court practices? I'm not answering that, and yes, that is a subject matter of study, as Professor Baxi has remarked. I am on Barak. He says that there are two central elements of the judicial role which a good judge is supposed to discharge. First is bridging the gap between the law and the society. And second, he says, major task is to protect the constitution and democracy. When we talk of this bridging the gap between the law and society, what is that constitutional makers left it to us, that is the judiciary. And Justice Krishna Iyer, in State of Karnataka versus Ranganath Reddy, has stated this as far as judges are concerned. The social philosophy of the Constitution shapes creative judicial vision and orientation. Our nation has, as its dynamic doctrine, economic democracy, sans which political democracy is chimerical. We say so because our Constitution in parts 3 and 4 and elsewhere ensouls such a value system, and the debate in this case puts precisely this soul in peril. Our thesis is that the dialectics of social justice should not be missed if the synthesis of parts 3 and 4 is to influence state action and the court pronouncements. Constitutional problems cannot be studied in a socio-economic vacuum, since socio-cultural changes are the source of a new values, and slowing off old legal thought is a part of the process, the new equity-loaded legality. A judge is a social scientist in his role as constitutional invigilator and fails functionally if he forgets this dimension in his complex duties. I think nobody would dispute this role of the Constitutional Court. And when the court is supposed to jealously guard the fundamental rights of the people, which includes access to justice to the marginalized section of the society, and that was the reason how SAL or PIL was invented. No doubt, as I said earlier also, there are shortcomings. Maybe at some stages, judges may have erred. At some stages, or in some cases, judges may have overstepped. But in this context, and without going into the detailed debate, what I say is that when you write the scorecard of the Supreme Court or the Constitutional Court for that matter, which includes high courts, the entire spectrum has to be kept in mind as to what the court has achieved in giving rights to the marginalized persons or the marginalized section of the society. If the Supreme Court has been able to create that kind of jurisprudence and has been able to successfully at least kindle the minds of the public, then I think to that extent Supreme Court has achieved the purpose which is enshrined in this Constitution. And therefore, both the sides should be seen, and I will request Professor Baxi, whenever he undertakes this study, please look into this side as well. Thank you very much.